Now we're going to discuss some of the cons, although we've probably discussed a lot of them while hitting on the pros, of why you wouldn't want to be in federal court. We had venue down as both a pro and a con, but I think we've beaten the proverbial horse on the venue choice issue. The joint pretrial order, we've discussed it very briefly, but what that is a document at the end of discovery that's jointly prepared and then so ordered by the judge or the magistrate, and it essentially lays out all the pertinent issues for trial. It includes witnesses, it includes deposition testimony that you're going to be using at trial. It includes jury charges. It includes kind of the kitchen sink about your trial. It talks about your experts. It is really laying out your trial before you try the case. It's a lot of work. And it's work that you're going to need to do in state court, but you're going to do it closer to trial. In federal court, you're going to do it essentially as discovery is completing and before you either get your trial date from the magistrate or you get placed on 72 hours notice by the judge. It's a lot of work, and on my first few federal cases, we referred to it as the dreaded joint pretrial order. We don't dread it quite as much these days because, again, if you're prepared and if discovery has gone well throughout the case, it's not quite as dreaded as you think. But there are people who still hear the phrase joint pretrial order and say, for that reason alone, I'm avoiding federal court. Again, I don't think it's a single issue that's significant enough to avoid federal court because of it, but it's something you need to be aware of. I think sort of the gist of a lot of what we've been saying about federal court is you need to be prepared, and you need to be prepared early. And the joint pretrial order is perhaps the best example of that. You need to be prepared to try your case months before the trial. But when the trial does come around, you've done a lot of the work you need to already.
Ken, if I may, on the joint pretrial order. One of the first cases that I brought in federal court was a case against one of those carriers who never pays until you're, after you've picked a jury, you're trying the case, and I had prepared the joint pretrial order. Now, it's called a joint pretrial order. Both sides are supposed to prepare it together. So usually one side prepares their position, everything else, and then the other side prepares their position. Well, when I did my first one, I had never done one before, so I actually prepared my adversaries, but I didn't prepare it in his favor, I prepared it in my favor, assuming, wrongfully, that he would look at it and change it. He did nothing. I sent it to him, he approved it, the judge approved it, we got to trial, and I'll never forget that we were sitting in the judge's chambers, and the judge turned to my adversary while we're getting ready to pick the jury, and he says to my adversary, he says, "You really have to settle this case." And the guy goes, "Why?" He says, "Well, did you look at your joint pretrial order?" And he goes, "Of course." He says, "You've basically acknowledged liability. You haven't asserted that there's a threshold issue. This case is going to the jury on damages only. Is that what you expect?" And I swear, he said, "Your Honor, I need to go outside and make a phone call." This was at 6 o'clock at night. I'm not kidding. 6 o'clock at night. I don't know who he was able to call at the carrier at 6 o'clock at night, but he came back in and I got the policy. So I have been a firm believer in federal court ever since then, but I've never had a joint pretrial order experience just like that.
And that, admittedly, is probably
not going to happen again.
A once in a career type thing.